and welcome to Stowe Talks, a podcast designed to support people going through a relationship breakdown and all of the struggles this brings. I'm Matthew Taylor.
And I'm Liza, family lawyers at Stowe Family Law. And today we're looking at debt and divorce. So I guess debt can be quite a big part of a lot of divorces these days. We perhaps live in a society where it's quite normal for, you've got your mortgage on your house, but you've also perhaps got a card loan and a credit card and a sofa loan. And, it's quite a normal part of society these days, I think, and quite accepted, isn't it, that people have these types of debts. So how are they dealt with as far as the divorce proceedings are concerned? And I guess, what if your only assets of the marriage are debts? Can you still get divorced?
Yeah, absolutely. You still can. I mean, we've got the differentiation, don't we, between the divorce and the finances. So you can get divorced doing the not being married part. You can do that at any stage, and your finances are independent of that. Now, obviously, what that comes on to is about sorting out the finances, ending up with your financial order, the document which sets out what's going to happen with the finances of the marriage. And when we talk about finances of the marriage, don't we? We don't talk about assets of the marriage necessarily. And there are plenty of cases where parties don't have anything or just have debt. And the court can make orders about that. So there are different types of debt, and they're all going to be treated in different ways. And it's very different if you have what is solely a debt case. And they can be some of the hardest cases, I think, when you've got parties who are just in debt, and particularly if they're struggling to meet those debt repayments. And these can be parties with actually quite chunky assets or quite decent incomes, but just debt can become a huge burden, a huge difficulty. And they're really tricky cases because they're legally quite technical, and can be quite expensive. But by definition, the parties often don't have the money to pay the legal fees at the time. So that's one end of the spectrum. The other end of the spectrum is, it's a sort of, we've all got a bit more debt really than we probably like, I would imagine. It's credit cards that need to be factored in and sofa loans and that sort of thing. So I guess we should probably go through the sort of different types of debt that feature commonly in financial negotiations. So, and there's a concept that we talk about a lot as lawyers, which are hard loans and soft loans. So maybe that's a good place to start, Lisa.
So hard loans, to put it very simply, are the types of debts where if you don't pay, they are going to come after you as far as court, they're going to issue court proceedings. So they will be things like your mortgage, your credit card debt. They will be specific loans with third party companies, etc. So anything where, they're not going to think twice about issuing a claim to the court if you don't pay. Soft loans, on the other hand, are loans usually from family members. And this is quite common these days, that it might be a family member has helped you to purchase a house, or they've helped you to pay the children's school fees, or they've loaned you money to help with your legal fees during the divorce. And so you won't necessarily in those cases have written agreements as to the repayment plans for those, how those debts should be repaid. And there could even be a question mark on, actually, are these debts or are they gifts? That have now just become debts because the parties are separating. And the courts make this distinction because often there isn't enough money to go around to meet needs. And what that means is that they have to be very careful when they're looking at separating the assets out as to how much is deducted from the pot, if you like. And often the courts will take the view that when we're looking at soft loans, so loans from parents or family members, that if these loans weren't repaid, they probably aren't going to do anything about it. They're not going to take their son or daughter to court to enforce payment. And therefore, the courts will often err on the side of leaving it off the asset schedule when we're looking at dividing assets, which can feel really, really unfair to the parties and also to those third parties who have loaned sometimes actually quite significant sums of money.
Yeah, I think there's also another way of looking at it, the way the court treats it when it's a soft loan like that, because that can feel unfair. I think that often an argument that, that I might run on behalf of a client who is trying to argue that something is a soft loan is, let's say a parent has lent 20k to their son to help buy a property. If that money was to be repaid and then the son wasn't able to buy a property, it seems kind of likely that that money will probably be reloaned. If the loan hadn't previously been called in, but suddenly it's because there's a divorce, the court says, well, look, that's a resource available to you, which is obviously one of the main criteria under Section 25 of the Matrimonial Causes Act, which the court looks at. So I think it's those two dual factors. And it's not to say that every loan from family member will be considered a soft loan. I think if you've got a history of repayment, that is much more likely for the court to take it into account. If you have been paying back a sum loan, you've been paying back £200 a month for the past year and a half, and then you get divorced, I think the court's probably going to say, well, look, there's an understanding there, isn't there? You were paying it back. It's more where the money's not demanded, especially if there's no written agreement, and then there's a divorce and someone says, oh, I need that money back now. You kind of think, well, is that something that the court would stand up? So once you've identified your hard and soft loans, how do you deal with them? What happens? How are they going to be taken on? Are they going to be paid off? What is the best course of action at that point?
Well, that depends on the facts of the case, doesn't it? And what assets? That's a big question, Matt.
Classic lawyer answer. It depends.
Yeah, it does. It completely depends. Let's say we've decided that there is X amount of debt that is going to be on the asset schedule. It's matrimonial, if you like, for the purposes of it. Or maybe that's another question, actually. Is the debt matrimonial or is it non-matrimonial? So when we're looking at debts and we're looking at, let's say, hard debts, they can be in joint names, they can be in one person's sole name. And we'll often get the question of, am I going to be responsible for that £10,000 credit card debt that they've got? It's in their name. So there can be an assumption that, I'm not responsible for that. And I think it's important to understand that actually, a bit like when we're talking about cash assets or houses, it doesn't really matter with divorce, whether it's in one party's sole name or joint names, it can still be classed as matrimonial, and that still goes with debts. And particularly if the debt was accrued during the course of the marriage, it was accrued for the purposes of joint outgoings. So perhaps, it was a family holiday, or it was because the parties have just been living a bit beyond their means and they've had to kind of go into the debt or use credit as a means of being able to meet their outgoings each month, then those types of debts are more than likely to be classed as matrimonial and to go on the asset schedule, whoever's name it is in. If, however, you've been separated, let's say for quite a while, the debt has been accrued outside of the marriage, and one party has just been living the life of Riley since you separate, and they've been going on nice holidays and have bought very expensive clothes and expensive gym membership and all of that type of stuff, then in those circumstances the court might actually say, that's not a matrimonial debt. That one we're going to class as that person's sole debt, and it then goes or it comes off the asset schedule for the joint assets, if you like.
Yeah, so it becomes sort of ring fence. It's like the reverse of what we've previously spoken about. If someone's got an inheritance and you're looking to ring fence it. But what's important to remember is that when you are looking at these, the court might say, okay, well, that's, non-matrimonial debt, so that stays with the husband. If the impact of that means that the husband then can't meet their needs and the needs of any minor children, the court can say, well, I'm very sorry, we're going to have to share this debt. And how you share it will depend on factors. So I think often, like family lawyers and the court, our preference is, because it's nice and clean, is, pay off the debt if you've got the ability to, particularly if you're looking at selling a house. Well, our calculations would generally start on the assumption of pay off house, sell off debts, what's left to rehouse. Now, that might mean that people can't then rehouse. So people might actually choose to retain the debt and just service it on an ongoing basis. And particularly if it's something like a car finance agreement, that will generally stay in place because you're not going to get rid of your car necessarily. But if it's credit cards that are unsecured borrowing, you don't have to pay them off, then you might choose to retain those. It's got a knock-on effect on your mortgage capacity because of affordability with the ongoing repayments. But that's something that can be looked at. But we would make sure that when you're doing the assessment of the finances and you're looking to reach the starting point of equality of division for matrimonial assets, that the liabilities are factored in. So it's not 50-50 and then each person keeps the debt. Normally, it's factor that in. Whether you then pay it off or continue to pay it, it's going to depend on the circumstances. And this is where the flexibility of sorting stuff out outside of court helps, because you can probably be a little bit more creative if you want to decide that you're going to jointly retain some debt, if there is a car loan that's attached to one person, but the other party is actually driving that car, but they're going to agree to pay that, how does that work? So you can be quite creative with it. I think if push comes to shove and the judge is made to make an order, simplicity and clarity is generally preferred. And if it is possible to pay off debts, it's usually going to be the approach. I mean, is that fair, or am I being a bit simplistic there?
No, I agree. It comes down to, agreeing things outside of court do give you more flexibility. It's about then making sure that any agreements you've reached are binding, and how we're going to draft those into orders to protect both parties. Because obviously, if, for example, in the car loan scenario that you gave there, the loan company are ultimately still going to come after, let's say, husband, if the car loan's in husband's name, even if wife is the one that's agreed to pay the loan and is the one that's driving around in the car. So it's just making sure that you get any agreements properly drafted so that they have some, teeth to them, if you like, some enforceability behind them. But yeah, no, I would completely agree with that. As far as, let's say Mrs. Smith has come to see you and she says that her husband has just disclosed that he's got a £20,000 credit card that was built up during the course of the marriage, but she had no knowledge of this. How is that dealt with?
I mean, it depends, as ever. What's that money gone on? Has that money been used to support the family? Has it been a couple of holidays that the family's all gone on? Has it been paying for clothes for the kids? If its effect is matrimonial, and you can get disclosure of the bank statements to work out how this has been accrued, if the effect of it is matrimonial, then the court's likely to say, well, look, you've had the benefit of this. You might not have known about it, but it's not uncommon for parties to not really know about the finances during the marriage, and that might just be a function of the parties deciding who the sort of chief financial officer of the family is. And there's actually no dispute that the debt has helped the family to live the life, so therefore it's only fair that it's factored in. If, however, that has been debt that has been accrued solely without consent, without knowledge, and without the rest of the family having benefit, so that solely the husband in this case has been doing stuff on his hobbies, or perhaps it's been through an affair or something, or something that's really upsetting behind it, and that's money that's gone on other, dates and relationships and things, which is clearly non-matrimonial, then there's an argument to say that should be classed as non-matrimonial and excluded from the sharing principle. So I've certainly had cases like this, where you have to identify, okay, there's this debt, we weren't expecting it. Let's see where it comes from. Let's see the credit card statements. Let's see how it's been accrued. Trace the transactions through bank accounts if you need to. And either you find out the truth of it, or if they just refusal to provide disclosure, you ask the court to draw adverse inferences and say, well, we think this has probably been spent somewhere that the husband doesn't really want to tell us about. So there's only going to be one reason for that. So you can try and exclude it on that basis. I think those cases tend to be a rarity. It tends to be it tends to be a knowledge gap thing. There's obviously cases where there is economic abuse behind all this, and I think that's a very different flavour of things, and perhaps something that it needs a more specialist approach than we've got in this short podcast to talk about. But where it's not abusive behaviour is either the decision in terms of the management of the family finances, or it's not great behaviour that's a bit duplicitous but falling short of abuse. It's kind of lies, it's affairs, whatever it may be. That's a slightly different situation. So there's an argument for it. Again, it comes back to, though, if you do that approach, are needs still able to be met? It's potentially a conduct argument. So it might be conduct which is inequitable to disregard. That's the phrase from the statute about someone's spending if it reaches that threshold. And the financial effect of including that would be to penalise the sort of innocent party. Then you can factor it in. So, they can be fairly complex arguments to run. It's something to be really clear about being proportional about, because the debt really needs to make a difference to the overall settlement, a substantial difference, because you could spend a lot of money on legal fees chasing after it only to find out that you kind of spent more money on legals on the actual work. So, yeah, it's a tricky area.
What's the court's sort of approach in your experience on raising these issues as conduct? So, there have been cases that come to the court where one party has been a gambler, for example, or has racked up thousands and thousands of pounds using prostitutes, or, they do have a bit of the sort of gasp factor a little bit in that you think, oh, this isn't the usual run of the mill. But what does the court do in those circumstances?
So that gasp factor phrase is key. That has historically been the court's approach, is it needs to be something that does cause a bit of a gasp and then could factor it in. The gambling and the sort of the prostitutes and things like that, that's quite an interesting point, because the court also, in some of the case law, takes a view of, well, you take your spouse as you find them. And there's a case, which name escapes me for the moment, but where there was really quite substantial debt from gambling and from drug use. And the court said it was matrimonial because the husband had been open about being a drug addict and a gambling addict and had sought help for that, and the wife had supported in that. And the court felt that to carve out that aspect of his personality when the wife was aware of it throughout the marriage, because it no longer suited her, was something that it didn't want to do. And that's a judgment that will feel very, very harsh to a lot of people. I think the approach to that is changing. I think the court's approach to debt and really linking into economic abuse has changed over the past sort of couple of years. So 2023 onwards, there's a couple of judgments that start to recognise that actually this not telling people about spending can form part of a wider part of an economic abuse. And there's been a little bit of a step away from the gas factor. A couple of judgments which said, well, the gas factor is a bit of an outmoded concept. We need to look at things in the round. So it's tricky. I think it's always been a very hard thing to run. I think it's probably getting a little bit easier, but I think there's probably a bit more case law needed. I think the court's approach is still developing and changing. What do you think? I mean, in your experience, Lisa, running these cases or being involved in these cases, what's your advice to clients on how the court might approach things?
I think, what you said is correct in that they're just really difficult cases to run, because often the cost of trying to argue these points far outweighs the benefit that you're going to receive in sort of 95% of the cases. It can be very difficult for parties because they can feel that it's very unfair. Mm-hmm. And we talk a lot about sort of the courts reaching a fair result. And this is something that can really stick with them, particularly if it's not a debt that they knew about, or if it's not a debt, if it's a debt that they have had, they feel that they've had absolutely no benefit from, if you like. But yeah, certainly the cases that I've seen, the courts are really, really reluctant to exclude these types of debts, because often, unless you're looking at a very big money case, there's just not the money there to be able to exclude them and still meet both parties' housing needs. But again, the understanding sort of the coercive control and financial abuse, I think that is starting to come through, but I think we're going to sort of see that really develop in the next couple of years. And it does take a little while for the courts to catch up with concepts that society are kind of getting on board with more. And there is certainly change within the legal profession. There's lots of advocacy about this at the moment, but it does take a little bit of time for those things to really whittle down to the actual judgments that we're getting through.
Yeah, I'd agree with that. I guess maybe the final thing to kind of discuss is where you've got structured debt arrangements, where you have debt management plans. Maybe someone's had CCJs, county court judgments against them because of historic debt. What impact can those have on the settlement and how people can look to move forward with their lives?
I think the impact of those types of debts is the impact they have on things like mortgage raising capacities. If we're looking to, for example, sell the house and buy a new house, it may be that actually that's not possible because the party isn't going to be able to get a new mortgage. And therefore, we're either looking at having to retain the family home for a period, if that's affordable to do so, because, they've already got that mortgage in place, if you like, or we're looking at moving sort of into more rental agreements. So I think it's the debt itself is probably treated is treated in exactly the same way as any other debt, but the impact it has is more on the forward planning for what's going to happen after the divorce and moving the parties forward and setting up their new lives, because there are impacts there that the court has no control over.
Yeah, I think that's absolutely right. And a lot of these debt management plans, if you are getting divorced, there is something quite often in those agreements which requires you to notify the management company, because they know they're going to get the money. Prior to getting divorced, it may be possible that they may accept an offer, so you pay off the entire lump sum but a lesser amount. I think taking advice on that from a debt specialist is really important, because that's going into financial advice that we can't provide. So I think maybe to finish on, a couple of sort of top tips from us might be good about how to handle debt. And so what I sort of like to flag is just kind of expanding on that point a bit, is that I think getting some advice from a debt advisor is really, really important if it's problematic. If you are concerned about meeting ongoing payments, if you're concerned about having to repay huge lump sums and not being able to service your income needs, and particularly if you've got high levels of debt repayments and then you are trying to fund two households because you're separated, it can be enormously draining, incredibly stressful, add to anxiety, and make you very unwell at what is a stressful time. So there's loads of good resources around. So there's a great charity called Step Change. They're the debt charity there we're talking about. There are plenty of free resources online, plenty of journalists and things who will be writing about debt all the time. So I definitely go and do the research and try and work out how it suits you, because really fundamentally, particularly in that interim period where you're trying to sort the divorce, you need to make sure that you're carrying on servicing the debt, because if you don't, and it could be debt in the husband's name, and the wife needs to make sure that's still being serviced because you're linked financial persons, it could have a really negative effect on both of your credit ratings if you see your experience score tanking because you're not making repayments on these debts. So I think that would be my main sort of advice, or sort of top tip to deal with it. I mean, Lisa, what about you? Top tip for dealing with debt and divorce?
Yeah, probably two. So the first one is just get to grips with your figures, because I think there is a tendency for people, as they are accruing debt, to put their head in the sand a little bit and just not open the envelopes or the emails. And you need to know what the figures are. So, what's the amount, what are the surrender values of these debts? What is the amount that needs to be repaid each month? What's the term of all of these debts? Like, let's get that level of detail about everything. And then secondly, just proportionality. Just think really, really carefully before getting too stuck into arguing about debt, because you will often spend far more money arguing about it than if the debts were just agreed to be repaid in some format. So that constant sort of cost benefit analysis of, actually, is it worth going down this route? So that's it for this episode of Stowe Talks. Thanks for listening. If you would like more information on our podcast, head over to stowtalks.co.uk, and please rate, like, share and review this podcast where you can.